yea, oh yea. All persons having demanded a form of business before the Honorable United States Court of Appeals for the Fourth Circuit must draw nigh and give their attention. For the court is now sitting. God save the United States and this honorable court.
Mr. Early, when you're ready.
Yes, Your Honor, I'm ready. Good morning. May it please the court. My name is Eric Early. I represent appellant Don Blankenship, and I've reserved 7 minutes for rebuttal. The ultimate question, as we all know, is whether the evidence in the record could support a reasonable jury finding that Don Blankenship has shown actual malice by clear and convincing evidence. That's right out of Anderson versus Liberty Lobby. And the circumstantial evidence, as we argued below, as we'll argue again here today, in this case, when interpreted most favorably to Don Blankenship, required that the district court rule that a reasonable jury applying the clear and convincing evidence standard could reasonably have found for Don Blankenship. And just some important quotes from some of the key controlling cases. Again, Anderson versus Liberty Lobby, our holding that the clear and convincing standard of proof should be taken into account in ruling on summary judgment motions does not denigrate the role of the jury. It by no means authorizes trial by affidavits, credibility determinations, the weighing of evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of the judge. And importantly here, which something I'll be talking about, and respectfully, the trial court did not handle properly, let's say, is the trial court weighed the evidence in isolation. They did a surgical review of the evidence here. They didn't look at the entire story, the full context, the full picture, as would be presented to a jury in a court of law. I've tried a few cases.
Excuse me, Mr. Early.
Yes.
You mentioned credibility. Can you tell me what credibility issues are still at the heart of this case that need to be decided by fact?
Well, Your Honor, several.
I mean, the main one that you think is the...
Well, I'll give you one main one. Yeah. Chris Hayes, his credibility of MSNBC is directly, must be directly looked at. He has testimony, he's testified that he didn't remember, for example. We have evidence that shows that that very intelligent fellow, at a minimum, the jury can determine whether or not what he said was accurate, that he did not remember. His prior knowledge from the evidence that we presented, he knew Don Blankenship was a misdemeanor, not a felon. Then when Mr. Hayes was called to testify in this case, he testified in certain ways. I can give you the specific sites, but his credibility is called directly into question. Several of the Fox people are called directly into question. And the reason their credibility is called directly into question is, of course, they all said, well, I forgot, I don't remember, I didn't know. And as we all know here, there's a very tough standard. We have subjectivity, right? What was in the person's head? And that's why it is particularly important, not only for the trial court to go through all reasonable inferences in Don's favor. There are no reasonable inferences made in Don Blankenship's favor. But the jury could and must go through all reasonable inferences. And when you look at the totality of the evidence, as opposed to isolated in snippets here and there, Hart Hanks, the record must consider the factual record in full, the entire record. Here's a very interesting case. Iramo versus Rolling Stone, LLC, 209, F sub 3rd, 862, at page 875, or 87.
Just leave you back to that Hanks Hart.
Yes.
I read that case and understood it. They said that malice is a question of law for the court to decide, and that the burden is on you to present sufficient evidence to show subjective intent of the kind required by Sullivan. And so that the answer you just gave to Judge Gregory, the most you could conclude is that they were liars. But we're still lacking the question, I mean, it's a little bit like deciding negligence as a matter of law. If somebody advances a theory of negligence and he just fails to establish negligence, even if true, then we decide as a matter of law. And that's what I thought the Supreme Court said in Hanks, which was this is a question of law to be decided by the court, and the burden's on you to come forward with enough evidence to cross the line. Now, if you do, it seems to me, and then we get a trial. And so that probably should be the argument here that you focus on. That you came across with enough evidence of subjective intent that's imputable to each particular person who you accused of violating Mr. Blankenship's rights.
Your Honor, I can't disagree with the word you said. That's what the law says. And but what happened here, it certainly can be decided by the trial court as a matter of law as to whether or not sufficient evidence has been provided so a jury can determine whether or not actual malice existed. The problem here is the determination by the court did not take into account the entire context along with all of the evidence presented. And there were clearly issues of fact as to whether or not a jury, as to whether or not actual malice could be found. And so,
what is the evidence of, that's what I'm getting
let me go through it.
Is the actual evidence of malice. You have, I think, nicely laid out the evidence of motive. We have some, particularly in the Fox case, we have those emails coming in showing that there was motive to lean on or hit Blankenship. But of course, as you know, that's the heart of the protected activity in both Hanks and a couple of other Supreme Court cases. So the question is, where do we get to the high level of mental maliciousness that is required under this pretty strict standard, and they have to have clear and convincing evidence? We could question Sullivan, and I think people are starting to question Sullivan in the public debate. But as of now, that's, as you recognize, that's a high standard. And
no doubt we're stuck with Sullivan right now. Hopefully that will change one day. But let me say one thing, Your Honor. Again, we have to put ourselves in a courtroom where a jury would be sitting, which is completely different from the setting where whoever went through every one of these snippets of evidence was sitting. And a courtroom where there is a jury sitting gets a full picture portrayed for them. And it's within that picture, it's within that story, when they hear the very same evidence that we presented to the court, and I can go through a bunch of that evidence for you, a jury can reasonably infer that, yes, indeed, these statements were made with actual malice. This case first, then I'm going to get into what was going on at that time, the overall picture that the evidence supports. This case that I just read you about called Aramo, arguably, and this goes right to the heart of what I just said, by the way. This is a quote. Arguably, a reasonable jury can find that none of the evidence presented independently supports a finding of actual malice by clear and convincing evidence. Taken as a whole, however, a jury could conclude otherwise, and that's what we're talking about here. Must be taken as a whole. The trial court did not. What was happening here at the time? It was April, it was May 2018. Don Blankenship was running for U.S. Senate.
But how does that show the evidence? What was the actual evidence?
Well, I'll give you the actual evidence, and Your Honor, and frankly, as you're not going to have anybody on the other side come out and say, yeah, you know, when I said that about Don Blankenship, I knew it was a misdemeanor, but I lied and said he was a felon because I knew that would make him look much worse.
what if every one of these people said, Mr. Blankenship was a convicted criminal who served a year in jail? Would we be here?
If they told the truth, we would not be here.
I'm saying said just that. In other words, they all reported this man's running for office and he's a convicted criminal who has served 1 year in jail.
We would not be here, Your Honor.
That's my thought. So really, we're not talking about the notion that, the common law notion that a person's convicted of a crime is per se libelous. This man was convicted of a crime. What we're arguing about is whether these people accurately labeled the level of criminal conduct. And as what you read in the record again and again, people didn't understand the difference between a felony and a misdemeanor. You know, in the state of Maryland, I think you can have 2-year misdemeanors or 3-year misdemeanors. Federal court, it's a 1-year definition. I don't know what it is in West Virginia, but it seems to me that many people on the street and many attorneys have a hard time defining the difference between a misdemeanor and a felony, especially when the man has served a year in jail. We had that one email, somebody said, you mean he served a year in jail and he wasn't a felon? Of course, if he served a year and a day, he would be. And so the problem here is they're clearly dumping on him. They're clearly targeting him. You presented, I think, convincing evidence on that. Politically, they were trying to oppose his candidacy. But that's the heart of the First Amendment debate going on. The question is whether the use of the label, not the actual fact, he was a convicted criminal, he did serve a year. But the question is the use of the label felon, was that maliciously done? And that requires quite a bit of evidence.
Well, Your Honor, we presented that evidence with all due respect, and a jury can determine, and certainly a jury can reasonably infer from all the evidence whether or not that calling Don Blankenship a felon and a convicted felon, rather than calling him a convicted misdemeanant, was done intentionally to harm.
The word misdemeanant, I can tell you, because that word is almost unknown to people. They
Well,
call him a convicted criminal.
let them call him convicted of a misdemeanor. When was the last time, and I won't say it that way. I can't remember the last time somebody who was dumping on a candidate that they had actual animus towards was saying, and he was convicted of a misdemeanor. Never do it. They'd look ridiculous. But, Your Honor, let me...
The key in this case isn't the misdemeanor aspect. The key in this case is he served a year in jail. And people can't understand how you can serve a year. I think the person on the street would say a misdemeanor is something you get fined for, whatever, but you don't serve time. But if you're going to serve a year in jail, it's a serious crime.
Even your client noted that he was the only one in the prison that had been convicted of a misdemeanor. Everyone else had been convicted of a felony.
With respect, Your Honor, we have Chris Hayes, who knew in advance he was convicted of a misdemeanor. We have S.E. Cupp, CNN, knew in advance he was convicted of a misdemeanor. We have many people at Fox, knew in advance he was convicted of a misdemeanor. And then what happened, and the evidence shows, Don Blankenship shocked the world at that debate on May 1st, which, by the way, one can infer, and a jury can certainly reasonably infer, that all the higher-ups at Fox watched their debate, the only nationally televised senatorial debate, primary debate in the nation right then. Don Blankenship says, I was not convicted of a felony. I did a year, but I was only convicted of a misdemeanor. And so they knew beforehand, and yet things changed, because after that debate, as our evidence also shows, Don Blankenship was surging in the polls. And they didn't, as the evidence also shows, they did not want Don Blankenship to win the primary because they, meaning Mitch McConnell in particular, did not want Don Blankenship to win the primary because he believed he could never beat Joe Manchin. And plus, Mitch McConnell's animus to Don Blankenship cannot be, said strong enough. The district court on this issue of felon versus misdemeanor said it very clearly, and we agree with this. It was in their motion to dismiss ruling. This is a quote. A person either is or is not a felon. There is no in-between room for substantial truth. And, the D.C. Circuit put it starkly. When the legislature designates a crime as a felony, it signals to the world the highest degree of societal condemnation. That was the Medina versus Whitaker court, 913 F. 3rd, 15152. And on Illinois court said, society at large views a felon far differently than a person who has committed an offense resulting in a misdemeanor conviction. That's Myers versus the Telegraph, 773 Northeast 2nd, 192, 198. Illinois Court of Appeal 2002. This is about, Your Honors, respectfully, what the common man and woman in society believed and thought when they were told felon and convicted felon, even worse than felon, rather than told misdemeanor or misdemeanor.
Mr. Early, let me follow up on Judge Niemeyer's sort of a hypothetical, really, I guess a counterfactual, really, because it's so close somewhat to the facts. When we ask you whether they had said, she said, let me add something to it. If they had said he was convicted of a crime, sentenced to prison for conduct which led to the death of 29 people, we wouldn't be here, would we?
We would be here. That's false.
That's false?
Yes, Your Honor.
The conduct is not related at all?
Not related. In fact, let me give you some quotes because that's one of the problems with every single thing the defendant said. They're always implying that Don Blankenship somehow was responsible for
No, I didn't say responsible.
Well-
I said related, conduct related. Is that false or not?
When you say related, it infers, frankly, that he was responsible and that court found him responsible in some way for either causing the explosion or causing the death. Let me read you some quotes directly from the trial court transcript, Your Honor, in the criminal court. Mr. Blankenship was not charged with or convicted of causing the explosion at Upper Big Branch or with causing the deaths of any minors at Upper Big Branch. Mr. Blankenship was not charged with causing the mine explosion at Upper Big Branch. Here's another quote. In fact, neither the cause of nor the responsibility for the explosion is at issue in this case. And I might add, by the way, when Don Blankenship was literally on trial for his life in the trial court proceeding, it was 40 miles away from that terrible disaster. The galley was filled with families who had suffered terribly over the loss of their family members. The jury, of course, ruled, and the jury came down, and the people spoke through the jury. And the jury said, Don Blankenship is not a felon.
So you would say because they said related, that would give the inference that he did. So that would be here, right, for that.
I think we very possibly would be here, Your
Let's see
Honor.
how broad it is. Okay.
But let me give you something else so important.
But your time is up, so you better wind it up.
The Judge Napolitano situation is critical. He comes in on August 25th. He testifies, Don Blankenship convicted of manslaughter. It was brought to his attention immediately by Mr. Blankenship's campaign team. I wasn't convicted of manslaughter. The evidence shows that day after day after day, Mr. Napolitano, Judge Napolitano, and his producer were approaching Fox. We want to get back on. We want to retract. We want to get back on. Please, we want to retract. He's only convicted of a misdemeanor. The evidence shows that Fox and friends would not let him back on for that, although it would let him back on to talk about something completely different. Martha McCallum, who had clear animus towards Don Blankenship, would not let him back on to correct that. That is more than a mere failure to retract. I understand how failure to retract is just one thing you look at for actual malice. That was doubling down on a lie, doubling and tripling down on a lie. A normal failure to retract, somebody wants to do a retract, and the publication says no. Here, he said, I want to retract. Please, I want to come on. And how does Fox know it needed to retract? Because 2 weeks after the primary, remarkably, Martha McCallum had Judge Napolitano on to do the retraction.
But even then, he didn't address the manslaughter statement that he made. He talked again about the felon. And he never even stated that Mr. Blankenship was a felon.
We all wish he had done more of a retraction, but the real point here is that the Fox hierarchy, and it can certainly be reasonably inferred it was the Fox hierarchy and all of these people, they made sure that he was not coming back on to talk about Don Blankenship and manslaughter until after the primary was over. That's much more than a mere failure to retract. In fact, it is a doubling and tripling down with actual malice to make sure this lingered, this lie, this falsehood lingered in the minds of the public at large. I'm out of time. I apologize. Thank you.
Thank you, Mr. Early. Mr. Bain?
May it please the court, my name is Kevin Bain, and I represent all of the defendants in this case. Not only is there no clear and convincing proof of actual malice in this case, I submit there's compelling evidence that there was no actual malice. What the plaintiff has to prove in this case is that these defendants knew that what they're about to say was false, or had a high degree of awareness that it was probably false. And they must prove that by clear and convincing evidence. So let's consider what a jury would have to find in this case. A jury would have to find that the defendants essentially said to themselves, I know Mr. Blankenship is not a felon, or I realize that it's probably false to say that he was, but I'm going to say it anyway. Now think about that. A reporter is consciously aware that the term felon is false, or probably false. The word isn't key to his report or her report. It's just one word to convey the idea that there was a conviction, serious conviction. The word doesn't make the story any more powerful. It doesn't get the story any more attention. The reporter is going to subject himself to criticism, and he might even look stupid if he uses a word he knows is untrue, but he does it anyway. That doesn't make any sense. So what the plaintiff has to prove in this case is something that makes no sense. That's the first level of argument I've got here, common sense.
Well, I'm not sure that that goes really very far, because let's say someone had actual malice and said, I know he's a misdemeanor, but I'm going to make him look like a felony because I just don't want him to succeed in the primary. And and our position or our network is that we don't want him to succeed, so we're going to call him a felon. That makes sense.
The felon.
We're going to call him a felon in order to cause him not to be elected. You said it just doesn't make sense to do that. And I say it could make sense if there was evidence to show that direct malice, that they intended to use the word felon in order to aggravate his wrongdoing and try to persuade the people not to elect him. And it seems to me that's their thesis. Whether they got the evidence to support it, but I'm just pushing back a little bit on your notion that it wouldn't make sense for a reporter to say it. I think they could have. And there is some common sense there.
I would say, Your Honor, that the word felon is the least of it. If they really wanted to make him look bad, they would have talked about the mine explosion that killed 29 people.
Well, they did. They talked about that. And they talked about the convictions, and I mean, there was a big political debate going around him. He certainly was a center of attention, and the press covered it all.
Well, Your Honor, I guess what I would say to that is that many of them just used it in passing, saying convicted felon, when the story was about, many of the stories were about, say, the fact that Mitch McConnell and Donald Trump were opposing the plaintiff's candidacy, and so the word felon is a passing reference in the course of a discussion about something else. But let me get to the second point, and that is that the common understanding of this word felon is someone convicted of a serious crime. If you ask someone on the street what a felon is, they'll probably say it's someone convicted of a serious crime. If you look in the dictionary, the definition is someone convicted of a serious crime. The judge said it was a serious crime, so it's not surprising that over 100 media outlets use the word felon. And it's hard to believe that 100 defendants, 100 media outlets, or 15 defendants used it knowing it was false. But there's a third level of evidence here, the contemporaneous evidence of what these actors actually intended. Mr. Blankenship contacted exactly 2 of the defendants to point out that the word felon was inaccurate. In both cases, the immediate reaction of the reporter was surprise and confusion. Mr. Cavuto at Fox says, on the air, when Andrew Napolitano is on, they're interviewing Blankenship. Blankenship says, I wasn't a felon. I was convicted of a misdemeanor. And Cavuto says, on the air, live, spontaneously, so what are you if you've served time in jail? Blankenship explains. Cavuto says again, well, that would be a little more than a misdemeanor, right? And when Mr. Blankenship leaves, Napolitano, who was a judge, says he was right. It wasn't a felony, it was a misdemeanor. And Cavuto says to Napolitano, so just serving a year in jail doesn't make you a convicted felon? Napolitano says that's correct. And Cavuto says, and that was his point. And by the way, there was no refusal at Fox to correct the reference to manslaughter. Mr. Napolitano simply said, I'd like to go on and discuss the complex legal issues surrounding Mr. Blankenship as one of 3 stories he was proposing to Fox. And the producer said, well, we like the 3rd story. He didn't say, I made a mistake when I said manslaughter, I want to get on and correct it. He didn't say that to anybody. There was no affirmative refusal to correct that. And as Your Honor pointed out, the word manslaughter is not part of this case. They concede Mr. Napolitano didn't have any actual malice, and he never said felon. So that's the first case. The second time that the plaintiff, his campaign manager, actually contacted one of these defendants was when the campaign manager contacted Meredith McGraw at ABC to say, hey, that was a mistake. McGraw tells John Verhoeven, who had said felon, hey, we got to correct that. And immediately, response from John Verhoeven in an email is, Meredith, can you send me the exact language on this? Blankenship was sent to federal prison, but he was not convicted of a felony? Later on, when she says, yes, that's right, he says, sorry, I thought I had it right on that. I had seen it in an earlier story. That's my bad. I wish I'd been more careful. So maybe you could argue that he was negligent, but negligence isn't the standard. And Mr. Blankenship surely understands the surprise and confusion that Mr. Cavuto and Mr. Verhoeven had. He testified in this case. I don't know of anyone that's heard of anyone going to prison for a misdemeanor. I don't know that anyone in the media has ever heard of such a thing. So I guess I would say that whenever there was notice to one of these defendants that a mistake had been made, the immediate reaction was, oh my goodness, how could that be? And then when they're told that's the way it was, they correct it on the spot. And there was no effort to contact any of the other defendants to say they had made a mistake. Yet there is some contemporaneous evidence there as well. Counsel talks about Chris Hayes and his credibility. He says he knew it was a misdemeanor. 2.5 years ago, Hayes had said, oh, it was a misdemeanor. But the night before he went on the air to say felon, he was having a conversation with his producer. And the producer actually records these conversations. You might ask, why is the producer recording the correspondent? Well, it's so that he can know exactly what to put in a script when there's a script. So he records the conversation.
Those two competing pieces of evidence. You have the 2015 emails back and forth between Chris Hayes and some of the other employees.
Yes.
And then you have these 2018 email and the conversation with the producers. But those two items of evidence are competing. So was the district court engaging in some type of balancing or weighing that evidence?
Because the plaintiff has the burden of proving by clear and convincing proof there was actual malice. And in Mr. Hayes' case, there's one piece of evidence that negates any inference you might draw from either of those other pieces of evidence, one of which is 2.5 years ago when he did say misdemeanor, and the other is several months ago when he had done a piece showing graphics. There's no evidence that Mr. Hayes had ever read those stories, the headlines of which were put on the screen. So there's no evidence they knew the content of those stories. But the contemporaneous evidence, which proves beyond any doubt what he believed, was the night before when he's talking to his producer in a recorded conversation. And he says, and the producer's saying, well, let's run that advertisement that Mr. Blankenship is running where he says, you know, Hillary should go to prison, lock up Hillary. And what's Hayes' immediate reaction? An expletive, like holy mackerel, like that's a convicted felon, dude. So his immediate reaction on the spot was felon, which is the exact word he used the next day on the air. So that's, with that evidence of what was in his mind, contemporaneous evidence of what was in his mind that day, there could never be clear and convincing proof that in fact he knew what he was about to say was untrue. If I might, I know you don't have to decide the case on this ground, but let me say a word about falsity. They have the burden of proving that this was materially false by clear and convincing proof. I would say, Your Honors, it's impossible for a jury to conclude by clear and convincing proof in the circumstances of this case that the word felon was false. I'm not arguing that it would never be false to call a person a felon who is only convicted of misdemeanor. I am arguing that in this particular case, which involved, in the words of the district court that sentenced Mr. Blankenship, a crime, very serious conduct, a very serious crime. In this context—
What was the conduct that the court said it was serious, made that serious crime?
The conspiracy to violate mine safety standards. It was a conspiracy to violate mine safety standards, and the conviction, the prosecution was prompted by the explosion that killed 29 people, and the sentencing judge said, this is a serious crime. Your conduct was very serious. In this case, the crime fits the dictionary definition of a felon, someone convicted of a serious crime. This court has upheld summary judgment on the ground of substantial truth in a number of cases. In one case, PBM Products against Meade Johnson, a Lanham Act case, the court affirmed summary judgment on the grounds of substantial truth, and he looked to the dictionary definition of the term lie, which could mean simply a falsehood or a deliberate falsehood. And the court said, well, one definition is it's just a falsehood, so the word was substantially true. So that's one case in which the court looked to a dictionary to define substantial truth and took one of two definitions and said, well, that one fits, it's true. The question, of course, as this court has said, is whether the gist or the overall effect on the reader or viewer would be materially different if instead of saying Mr. Blankenship was a felon, they had said he was a convicted criminal who was sentenced to a year in prison and who received that $250,000 fine. Now, as Your Honor said, that's not materially different from what was said. Indeed, even as a technical matter, it's hard to say that the error here was material, even if you look at it in a strict legal sense. In many states, this crime, punishable by 1 year in prison, would be a felony. It's a misdemeanor in only about half the states. So even technically, it would have been true in half the states. But the fact is the test is not technical meaning or legal meaning, precision. It's substantial truth and what the effect was on the reader or the reasonable viewer. And I submit that the effect would have been no different if these defendants had said a convicted criminal sentenced to a year in prison and received a $250,000 fine. But even if you don't want to decide the issue on the case on the grounds of substantial falsity, that colors the actual malice argument. Because what all of these defendants have testified to is consistent with a common understanding, common usage of the term felon. So it's not like the testimony doesn't make any sense. And so on the credibility issue, the jury would have to decide by clear and convincing proof that the choice of one word rather than something else that meant something close, or that was deliberate and intentionally false. And I submit that it would probably be impossible to find material falsity, and even more difficult, more impossible to find that in view of the contemporary evidence, the common usage, and quite frankly, the fact that it doesn't make sense that someone would consciously say, I'm going to use the word felon, what criminal would do, and if I really want to make Blankenship look really bad, I can talk about the explosion, I can talk about the fine, I can talk about the prison sentence, and many of these defendants simply passed right over. Some of them did explain after they used the word felon that it was a conviction for violating federal mine safety standards, and he got a year in prison. So in that case, you've got all the facts right before you of the crime, concededly true, one word felon wasn't legally precise. How does that make it false? And how does that support a finding of actual malice? I submit, Your Honors, that it does not. The main argument on the other side is that at some point, some of these defendants had some level of awareness that Mr. Blankenship was not a felon. But that is a long way from evidence that any of them had a high degree of awareness that A, it was a misdemeanor, and B, that meant that the word felon doesn't fit. So the evidence of prior notice is oftentimes something that was uttered in Mr. Hayes' case 2.5 years ago, or many months ago, or something that was on live television, easy to miss, something that was buried in a document and didn't stand out. What stood out to every one of these defendants, as they testified to, was that he served a year in prison for a very serious crime, so they thought that the word felon fit. And think about this. Neil Cavuto, who they talked about, was a 35-year journalist who had worked on the McNeil-Lehrer report at PBS, at NBC, at CNBC, before coming to Fox. Now, he's jeopardizing his entire career and his entire reputation if he uses a word he knows is untrue. That's why I submit to Judge Niemeyer, it's hard to believe that someone with that kind of a record would say something he knows is untrue when he can make the same point using a different word. That's what they have to prove by clear and convincing evidence. And as I said, all they can come up with is some evidence. In some cases, there was some level of awareness at some time in the past. And there's no evidence that at the time that these reporters used the word felon, that at that time, they had a high degree of awareness that it was only a misdemeanor, and that means I can't call him a felon. Many of them testified, understandably, that I didn't even realize there was a difference between misdemeanor and felony, or I wasn't thinking about that at the time. I was just trying to use a word that would convey to my readers and my viewers that this was a serious offense. And so felons seemed to work. And so they used it. They also, they talk about how, Nassel said that Mr. That Mr. Cavuto knew that the word felon was wrong. The evidence there is so thin of his knowledge. Another Fox correspondent, Peter Ducey, made a fleeting reference to a misdemeanor in the middle of an hour-long program on live television. There's no evidence that Mr. Cavuto even noticed that one word on live television at the time, much less remembered it 2 weeks later. Here's what Mr. Ducey said on live television that counsel says ought to have been noticed that that Blankenship wasn't a felon. Ducey said, Blankenship is best known here in West Virginia as being a former coal baron who recently served a year in jail on a misdemeanor conviction tied to his role in a mine collapse that killed 29 people. There's a lot of information in that sentence spoken on live television. Misdemeanor's the least of it. Coal baron, year in jail, mine collapse, killing 29 people. That's what jumps out at you at the time. It's hardly surprising that Mr. Cavuto didn't catch it at the time and call it to mind 2 weeks later. He does a 2-hour live television program 6 days a week and an hour live television program 5 days a week, all unscripted. Ducey's statement was on live TV, and Cavuto speaking 2 weeks later on live TV, 15 minutes into an unscripted program. He spent the first 15 minutes talking about Robert Mueller, James Comey, Donald Trump, Roger Stone, Rudy Giuliani, Connor Lamb, Martha Stewart, Stormy Daniels, and then he finally gets to Blankenship and he uses the word felon. It doesn't make any sense that he sat there and said, I know it's wrong, but I'm going to say it anyway. That's unreasonable. No reasonable jury could find that by a preponderance of the evidence. It's certainly not by clear and convincing evidence. I just don't think that the evidence in this case comes close to approaching what the plaintiff must show. He talks about they're entitled to reasonable inferences. Of course they're entitled to reasonable inferences, but they're not entitled to unreasonable ones. And they're certainly not entitled to any sense that the unreasonable inferences amount to clear and compelling evidence of actual malice. He talks about credibility, but while it's true that all of these defendants said, as every defendant does in every libel case, I believed what I was saying is true, okay, disregard that testimony, if you must. Although they all had good reasons why they believed it was true, and they explained their reasons, which make a lot of sense, that this is how I understood the word. I'm not a lawyer. In fact, none of these journalists were even covering the criminal case. They didn't write about the trial. They were covering a political campaign in which Mr. Blankenship was a very controversial figure. The president of the United States and the majority leader of his own party are trying to defeat him. And he and Mitch McConnell are engaging in name-calling back and forth. He calls Mitch McConnell Cocaine Mitch. So one of the headlines is, unusual campaign, quote, Cocaine Mitch. So that was the context of these reports. These reporters they're not court reporters. They're not covering the courthouse. They weren't covering the trial. They were covering a campaign, and they want to refer back to a trial that had taken place, and so they use the word felon. Even if you disregard their testimony, there's no affirmative evidence establishing by clear and convincing proof that these reporters or any one of them actually sat there and said, well, I know this is probably untrue, but I'm going to say it anyway because why would he do that? Why not say convicted criminal? That's the obvious thing to say. If you have any doubt about one word, you'd use that word, of course. And why would 15 people make that decision? Indeed, as Mr. Blankenship says, over 100 media outlets use the word. They all use the word because it makes sense. There's no evidence, no clear and compelling evidence that anybody here use it knowing to be false or believing it to be probably false. Thank you.
Thank you, Mr. Bain. Mr. Early, time reserved.
Thank you, Your Honor. I believe it was Justice Giles who started by asking whose credibility is on the line here for a jury. I just listened to the presentation from the opposing side, and one would think that these highly intelligent people, Chris Hayes, I may not agree with him in certain ways. The man is brilliant. Neil Cavuto is brilliant. Martha McCallum is brilliant. Mitch McConnell's brilliant.
You know, I'm not sure that gets to the problem, because the question is a linguistic problem. And the evidence, not uniformly, but most of the evidence that you've advanced were people that were confused about the term felony and assumed that when the important message that they conveyed was that the man served a year in jail. And the question then is, what do you call someone who's served a year in jail for a crime? And basically, these people were saying that's a convicted felon. As you know, under federal law, a person convicted for a crime in which the sentence exceeds 1 year is a felony. But I don't think anybody was thinking about those terms. I think they were using the word felony to communicate the seriousness of it by always adding that he served a year in jail. And the task that you have to come forward with is that when they use the word felony, they used it deliberately in contradistinction with an existing understanding in order to misrepresent that fact about, make a false statement about the situation. Cavuto, even at the very end, after it was explained to him, he says it doesn't make sense. Somebody served a year in jail and it's not a felony. And he stood corrected. But the point is, does that communication represent the intent that's required?
Your Honor, respectfully, in terms of whether it's merely linguistics or not, this is for a jury to decide.
No, it's a matter of law. Hart made that clear. The question is, when you bring forth evidence that's adequate to satisfy the standard, then you get a jury call. But until then, you have to satisfy two things. One, you have to satisfy the actual malice. And number two, even on summary judgment, you have to satisfy the clear and convincing standard. What was that? Anderson said that? Or
Your Honor, it's a matter of law if there's no material issues of fact. And there are
no issues of material fact.
Nope.
That, in other words, you have to rise to the level of showing what is required.
no doubt. And we did. That's the issue.
That's that issue on this appeal.
We did.
And that's what we're debating. But we're not saying that because this whole thing, there's confusion about their understanding about felony or not felony, and when they used it here and didn't use it here. The question is, what was the mental state when they used the wrong term?
And that's why a jury should hear directly from Neil Cavuto, Martha McCallum, S.E. Cupp, Dana Bash, and Chris Hayes, among others. Dennis Horgan, also of MSNBC, who wrote a script knowing that Don Blankenship was convicted of a misdemeanor, wrote a script that Joy Reid got on the air and just read, saying convicted felon. We need to hear these people, and we need to let a jury determine whether or not that actual malice existed. We believe we've presented enough to the trial court to get past a decision as a matter of law. There are disputed material facts on the actual malice issue. Credibility should be determined by a jury. All reasonable inferences should be determined by a jury. As far as circumstantial evidence, the law is clear. Circumstantial evidence is special evidence of concerted activity is as probative as direct evidence. That's a Jane Doe case. A jury may make reasonable inferences from circumstantial evidence even in a criminal case. That's the Martin case. Circumstantial and direct evidence contain the same inherent probative value. It is up to the jury to weigh the evidence. This is so even in criminal cases. That's West Virginia versus Guthrie, 461 Southeast 2nd, 163, 176, 1995. What we have here is, nobody in Fox said the word felon or convicted felon until an email came out. An email from the boss being Rupert Murdoch on May 6th. Both Trump and McConnell appealing for help to beat unelectable former mine owner who served time. Anything during day helpful, but Sean and Laura dumping on him hard might save the day. That's May 6th. That's with the polls surging.
Let me ask you something on that. That was sent to some employees, right?
That was sent to the leaders of the news organization, Suzanne Scott and Jay Wallace.
That was communicated to the reporters.
Yes.
Is that right?
We say that a jury can reasonably infer that was communicated to the reporters because, as I call it, the Fox Five, right after that email, there were 5 separate instances in the day right before the primary election of Don Blankenship being called a felon or a convicted felon. This is not only evidence of the conspiracy that went on, it's not only evidence of the reasonable inference that a jury can draw between Mitch McConnell's...
Nothing in that emails mentions the term felon.
That's true. That's true. But why did they all start jumping to the word felon? A reasonable jury can infer, we argue, that destroying Don Blankenship by these people on the air made the boss happy, made Donald Trump happy, made Mitch McConnell happy. I've got a list of reasonable inferences here. I'd like to get to some of them that the court should have drawn in Don's favor, did not draw, and then a reasonable jury could draw. As to Fox, a reasonable jury can infer that Fox intentionally failed to allow Napolitano's retraction. A reasonable jury can infer that the term felon was used with actual malice to harm Don, as opposed to using the term misdemeanor.
I'd say they would not use misdemeanor. I'd say they'd use criminal. He was a convicted criminal who served a year in jail. I think their important message throughout all of them, they all questioned, how can a person serve a year in jail and not be a felon? And this is the type of mental attitude that most of them revealed. Now, not all of them. You have quite a list in your brief. I don't remember how many there were. And each one we would have to address and do have to address. But my point is the generality that a felon was deliberately used with knowledge that that was erroneous seems to be just the opposite. They seem to use it thinking it was the appropriate label.
Well, Your Honor, again, this should be before a reasonable jury. This is a soundbite business. They don't go through all those words you're suggesting. It's a soundbite business. There was another soundbite that could have been used. Convicted misdemeanor. Haven't heard that one yet. That was the God's honest truth, by the way. A reasonable jury can infer that Fox did not allow Napolitano to retract because with actual malice wanted to continue to allow the lie to linger. Can reasonably infer that Fox called Don a felon 5 times after the Murdoch email with actual malice. Can reasonably infer that Fox and McConnell conspired to defame Don Blankenship. A reasonable jury can infer that everything, frankly, or so much of what Chris Hayes said in his deposition lacked credibility. The same with Dana Bash. I'm at the end here. I could go on and on about that, so I'd just like to say a few words in closing. In closing, Your Honors, and thank you so much for hearing us out today. In this day and age of ongoing questions about the strength of our elections, ongoing questions about government control, deep state control of candidates, ongoing questions about the truth and veracity of the media, it is time to let the people speak. This should be sent to a jury, just like Don's criminal case went to a jury. When they came out in much more difficult circumstances, said Don Blankenship is not a felon. They understood the difference between a felon and a misdemeanor. People, regular people. And so we respectfully ask this case be reversed and remanded back to the trial court. And because defamation, and of course we're asking the defamation claim to be sent back, we also would ask then that all the claims, conspiracy and false light, be sent back as well. Thank you so much.
Thank you so much. Thank you, Mr. Early and Mr. Bain for your argument. We can't come down and shake your hands, but no, we appreciate your arguments. But this is kind of rare because I guess you're with us again for the next argument. So we can proceed on with that. You may proceed.
Thank you, Justice Gregory. I won't go on and on. I said most of the arguments in the other one. Frankly, I don't think it'd be appropriate to go through my arguments about the other defendants when I'm only facing a different
Sure.
appellee right now as to Boston Globe. But in concluding that Mr. Blankenship has failed to produce clear and convincing evidence of actual malice, the district court failed to view the record as a whole in light most favorable to my client with respect to Boston Globe. And what's that record? The evidence shows that the copy editor, what happened is, and you know this, AP article comes down. Usually these news organizations take the AP article and they reprint it. And here somebody inside Boston Globe, a copy editor, gets the AP article and decides to add words to it. And what's the words he adds to it? And which, by the way, were in violation of Boston Globe's ethics policy. He adds the words convicted felon to the AP story. This was defamation, and what the evidence showed is that Daniel Coleman, the night shift.
Actually, I thought he had authority under the arrangement with AP to edit for their own purposes, the publication. And what he did is, if you read the whole clause, or at least a broader language of the clause, the AP language was, at least in my judgment, pretty awkward. Barren, I know we use a lot of adjectives, and what he basically did is separated it to try to get the same meaning. It looked to me that way. But the proof of the pudding in that case is the Boston Globe did do an investigation into that, and they concluded it was an honest mistake. And that's the only evidence we have about that.
Let me just go through a little bit of the evidence, Your Honor. I certainly understand what you're saying. But with respect to what the AP's policy is, that should not control
I'm
you.
not talking about AP's policy. AP had an arrangement with the Globe, and the Globe was allowed to use AP articles, and I thought there was a suggestion that the Boston Globe was free to edit it. But you can correct me if the record doesn't show that.
The evidence we presented shows that the Boston Globe itself has a policy, ethics policy, that requires editors to confirm that any changes made by the paper to an AP wire story are true and accurate. So it's not an automatic where the Boston Globe's folks can make these changes. And for this situation in particular, prior to what we call a libelous revision, the Boston Globe had published at least 3 articles correctly reporting Don Blankenship's misdemeanor conviction. And so, again, we'd like to, frankly, we'd like to get the copy editor into court. We tried to get him. We couldn't get him.
Did you notice his deposition?
Did we try and get the copy? All right, we tried to get the copy editor.
Did you notice his deposition?
We noticed his deposition. I'm going third hand here.
And why couldn't you take it?
I don't want to say misrepresent anything. We were told he was unavailable and possibly sick. We had limited time in which to get it, and we were fighting a number of things in terms of the total number of depositions we could even get in this case. So we took his,
But given how important his testimony wouldn't have been, why wouldn't you have asked for an extension of the time in order to conduct that deposition?
Your Honor, that's a brilliant question. And
But you did a 30B6, and the 30B6, as you know, gets the testimony of the corporation. A person, everything from the corporation, of course, is hearsay. Corporations don't do much speaking. And so we get a 30B6 deposition, and the officer comes and testifies under 30B6 as to what they found and concluded. And I could see that was the only evidence that related to this copy editor's work.
Your Honor,
Except the only way we could get to the copy editor's intent is if you somehow talk to the copy editor.
can I let my partner talk about that deposition scenario and why we didn't get the copy editor?
Well, since Judge Niemeyer asked the question and we're interested, yes.
Thank you, Justice Gregory. This gentleman has far more knowledge on that situation than I do.
Your Honors, our,
For the record, would you
my name,
state your name?
my name is Jeremy Gray.
Hey, Ms. Gregg, go ahead.
It might be easier when you're talking to remove your mask unless you're against it.
No.
No, just while you're talking, I don't want to make it inconvenient for you.
We were told by the Boston Globe and by their 30B6 deposition that this witness had no recollection of these events. So we made the decision in the context of this case where we had a limited number of depositions that we could take, not to take his deposition.
That to me is a little bit different story. In other words, you made the decision not to take it because he was reportedly didn't recall it.
Eventually, Your Honor, yes. I think it was noticed and asked for, and then
Well,
at some point, the 30B6 witness told us that he didn't remember.
The unfortunate consequence is that we now have no evidence about his mental state, except the investigation conducted by the Globe.
That's correct.
Under the 30B6, and that testimony basically said they concluded it was an honest mistake. Now, do we have anything to contradict that?
Your Honor, they concluded he couldn't recall. I mean, the Boston Globe.
But the Globe, the corporation said they concluded it was an honest mistake. That was the corporate testimony.
Correct. That was.
And his testimony was basically, I don't recall, and that was hearsay.
Correct, but that was what they in other words, the Boston Globe concludes that it was an honest mistake.
But my point is, it doesn't matter how you parse that. The point is, number one, the Globe as an organization concluded that it was an honest mistake, and the individual who was involved, the only evidence you have is that indirect evidence that says he didn't recall. So is that clear and convincing evidence that he deliberately intended to mislabel the crime in this case, as opposed to clarifying the phrase, which I think benefited from the change, except for he used felon instead of criminal or whatever. But he did clarify an awkward phrase in the AP report. But my biggest point is, I was looking for some evidence of his mental state, the subjective state of malice, and I didn't see. And you can point me to it. But.
Understood, Your Honor. But we did get from the PMK that the fellow said he doesn't remember. And let's see what a jury says about what he remembers or doesn't remember when we bring him in front of a jury, especially since he violated.
Summary judgment, and you have to come forward with the evidence you propose to put in. And if you fail in that effort, then the summary judgment will be entered against you.
We submit we created a material issue of fact on actual malice with respect to even the Boston Globe, even this thin record, understandably, Your Honor. And, you know, there were...
What's the conflicting evidence?
The conflict, the ultimate conflict on everything...
On this particular copy editor, what is the conflicting evidence?
Was whether there was a possibility of actual malice.
I want to know what the evidence was that was introduced about him, other than what we just discussed here.
Well, I'm going to talk about what we discussed and add a few things to it, if I may, Your Honor. One, he violated the company policy by changing this article. on the in the lead up to the primary election. 2, he doesn't remember why he did it or if he did it, apparently. 3, the record which we did submit shows that there are prior news stories from that very news organization that that show that Don Blankenship was a misdemeanor. And 4, I believe company policy at Boston Globe was, before you make a change to an article, you speak to a higher up, you speak to colleagues, and you also check what the actual, whether it's true or false or not. And, you know, this goes to another legal issue, frankly.
Of course, all of those facts fall right within the Hart statement, the Supreme Court's Hart statement. The failure to investigate, the failure to do this, the failure to do that does not amount to sufficient evidence to show malice.
Your Honor, Hart and Anderson said all reasonable inferences in favor of the non-movement, Credibility should be determined by a jury. There were no reasonable inferences with respect to, I'll just focus on this case, with respect to Boston Globe, Your Honor. We submit this case should be submitted to a jury. I agree with you. I don't disagree that this is a harder lift than what I was arguing in the last oral argument. And but I would say at the end of the day, Your Honor, I have, and we have, and the courts have, the law has, and our U.S. Constitution has, great faith in the people. Great faith in the people. The people who, frankly, in some of these arguments today, not coming from the court, I think were given short shrift. And I have great faith in the people. The people decided, as I said, Don Blankenship's not a felon. They understand the difference between felony and misdemeanor. And that was under far more difficult circumstances, frankly.
Earlier, I appreciate your argument. I'm going to let you continue, but I just want to, you said that twice, but I just want to, that when you said that these are the people, yes, there was a jury of his peers, but that's a special group of people because they sat through a trial and were instructed on the law by the court. And certainly they know that it was not a felony. But so you do have to put some context to those people who made it, because everybody doesn't get instructed by a judge who's trying to figure out what a misdemeanor is versus a felony.
But to your
Was the jury
point,
instructed about misdemeanor and felony? I thought the jury was given 4 counts, some SEC counts, which were felonies, and this conspiracy count, and they convicted him of the conspiracy count. Is there any evidence that they decided whether it was a felony or misdemeanor?
Your Honor,
I don't think so.
there were 3 counts. There were 4 counts, 3 felonies, 1 misdemeanor.
I understand
So I'm going to say, Your
they
Honor,
didn't do it on the basis of the counts were totally different types of claims. They convicted him of what the proof established, and they said he conspired to violate the mine rules. And it turns out that's a misdemeanor, but I don't think the jury was told that or decided that. It wasn't relevant. The
jury
question, what was relevant is there's a crime alleged, and they convicted him of the crime.
jury decided Don Blankenship was not a felon. And Justice Gregory, to your point, in front of a reasonable jury, we will be giving the reasonable jury all of those instructions, and to help the reasonable jury decide why being called a felon is far worse than being called a misdemeanor. So, in closing, Your Honors, again, I want to thank you very much for your time. This is a high honor and privilege for me and my client to be able to argue in front of and speak in front of all of you today. Me coming out here from California, it's a little warmer today, and love this city here. But at the end of the day, in this day and time, and I said it before, of ongoing questions about the strength of our elections, ongoing questions about the control and manipulation of candidates, major offices, U.S. Senate, questions about media truth, sometimes questions about biased courts. It is time to let the people decide. We believe that everything we're asking for is directly in line with the concepts and the provisions and the holdings of major United States Supreme Court cases. We again ask that, respectfully, that this case be reversed and remanded as well, along with the other claims. Thank you.
Thank you, Mr. Early. Mr. Albano.
May it please the court, my name is John Albano, represent Boston Globe Media Partners. I will be careful not to repeat anything that's been said before, but I would like to begin by summarizing some things that I think people actually agree on in the Globe case. Everyone agrees that the article at issue in this case came 2 weeks after Mr. Blankenship lost the primary, a primary that he says he lost because of 100-some articles that mistakenly called him a felon. The Boston Globe was not among those 100 articles that were published. So we sort of came onto the scene, I would say, 2 weeks after the car accident occurred. And there's no dispute that on the evening of May 21st, the Globe received a AP Wire service article that Mr. Coleman edited that article, and that the article he looked at in its original form had two statements that I would suggest are relevant here. The first was an introduction that described Mr. Blankenship as a convicted ex-coal baron, no reference to whether it was a felony or a misdemeanor. But when the article returned to that subject, the conviction, it described Mr. Blankenship as spending a year in federal prison for violating safety regulations in a 2020 mine explosion that killed 29 miners. There's no dispute that Mr. Coleman edited that and made a mistake. He edited it to say that the conviction was a felony. As we know, it was not. It was a misdemeanor. The district court, I would suggest, correctly said, after 2 years of discovery, okay, we know there was a mistake.
Your opponent suggests that that edit to link his conviction for violation of mine regulations is also false, because he was convicted of conspiring to violate mine regulations, but not, he was not convicted for the mine violation that led to the death of the miners.
Right.
That was a ventilation system. That was somewhat, there was some dispute about all that.
And if I follow that point correctly, Your Honor, there's two related points. The line I read was from the original AP article that Mr. Blankenship did not sue on. The line I just read that said he spent a year in federal prison for violating safety regulations in a 2020 mine explosion that killed 29 miners. That's the AP. That's a story that was not sued upon. Mr. Blankenship has voiced displeasure with the correction that was later published by the Globe. But as the district court pointed out, he didn't sue on that correction. He could have sued on the correction. I would say that the correction is not materially different than the AP story that was not sued on, not materially different than the first sentence in the affirmance of Mr. Blankenship's convictions, which said...
Let me ask you,
yes.
The copy editor began with an AP story and edited it.
Right.
Explain to me what the authority he had and the arrangement he had with AP to do that.
Yeah, there is a contractual arrangement with the AP, and Mr. Dahl was our 30B6 witness. He explained with others as well, New York Times Service and others. You can get their stories, and the agreement allows you to edit them. And it happens...
Those conditions on that editing?
No, Your Honor. Not in the agreement itself, which was an exhibit, but the deposition is in its entirety in the record. And Mr. Dahl did get the chance to explain. They get about 200 stories that potentially come, in the budget. They pick from the wire services, 20 of them or so, and then they cut them down to fit in the paper. So they are always changed. They are always edited. This particular article appeared on page 2. It's there's an example in the record, but it's used for wire service stories. The Nation, it's called. It's not local stories. Globe is a regional paper. This is where the wire service stories go. They get these wire service stories, and they are edited. Now, was there, Mr. Coleman made a mistake. I mean, there is no evidence in the record, though, that Mr. Coleman or the Globe had any personal hostility or animosity towards Mr. Blankenship. After all, it would have been odd for them to wait until after the primary was over to make this mistake. As counsel pointed out, they had previously accurately reproduced AP articles that described it as a misdemeanor. So there's no reason to think, well, they'll wait until after he loses the primary to join the campaign of calling Mr. Blankenship a felon. There's not even any evidence that Mr. Coleman knew who Mr. Blankenship was before he read that article. As I was preparing for this, I didn't grow up in Boston. I don't feel like I need to defend the provincialism that happens up there. You would need to have some evidence that Mr. Coleman knew who Mr. Blankenship was. So there's none of that.
Was there any evidence in the record that Mr. Coleman was involved in the prior stories?
No, there is not. There is no evidence. Would have been a different issue, right? If he had passed on earlier stories, we don't know if he saw them, or if he did see them, did he take note of the terminology misdemeanor or felony? What the plaintiff says is the district court ignored the cumulative evidence. In the district court's defense, I'd say what the district court did was he refused to double count or accept speculation, because what the evidence was that Mr. Coleman made a mistake, and that we had stories in our archives that correctly reported that it was a misdemeanor. Well, that's right out of the Sullivan case, right? Because the New York Times had articles in their files that would have proved that certain points in the advertisement were false, and the Supreme Court said that is not enough. You need to show that people in the editorial chain were aware of those prior publications, and there's no such evidence of that here. And then the plaintiff says, okay, here's the second point. He failed to check the archives. Well, that's just another way of saying Mr. Coleman made a mistake. He should have checked the archives. Well, yes, but that's kind of the nature of making a mistake. If you think you've understood what an article says and have correctly edited it, that is a mistake. And we know from all the case law that a mistake, negligence, is not sufficient for actual malice. So I of course, would want to answer any additional questions that the court might have, but I would submit that this case is, well, I shouldn't comment on a case I'm not a part of. This is a straightforward case in which a reporter made a mistake. There is no evidence to the contrary, and the district court should not be faulted, and in fact should be affirmed for ruling that there was not sufficient evidence for a reasonable jury to decide that Mr. Coleman or the Globe knew that that article was false or entertained serious doubts about its truth, and certainly not by clear and convincing evidence. And for that reason, we'd ask the judgment to be affirmed.
Thank you, Mr. Alabama.
Thank you.
Mr. Early, you have some time reserved.
Thank you, Your Honor. I won't be long. I do want to read briefly the retraction and why we did take umbrage with it. Because of an editing error, I'm reading now from the Boston Globe, June 14, 2019. Because of an editing error, a May 22, 2018 story about former coal executive Don Blankenship of West Virginia referred incorrectly to his criminal case. He was convicted of a misdemeanor for his role in connection with a deadly 2010 mine disaster. The Globe regrets the error. We took umbrage with the in connection words, and I pretty much explained why the last go-round.
Yeah, that's why I asked the question. So part of your case is that because they connected the role,
That's
as Judge Nehemiah said, it is not connected to the actual explosion, the 29. So that's a part of your case as well?
that's exactly part of the case, Your Honor. And I'm just going to say one thing in closing.
Just to be fair with that report, that I think that picks up the AP language that was pre-existing and has not been challenged. But quite apart from that, the investigation of Mr. Blankenship following the mine disaster was prompted by the mine disaster, and he was convicted of conspiring to, it was numerous, I don't remember how many, violations over the years, and with emails where he directed his subordinates not to address the problem. So the mine had systemic problems, but I think you're fair in saying that the particular problem causing the accident may not have been listed among those. I think it was something with the ventilation system, as I recall. And so it's related, but it's not related. It's not directly causative.
Thank you, Justice Niemeyer. I'm just going to close by saying one other thing. It's our understanding, and like I said, hopefully we get in front of a jury and we'll know it for sure, but that nobody has ever been elected to the United States Senate who was convicted of a felony. And with that, I've got nothing further to say. Thank you so much.
Thank you, Mr. Early, Mr. Albano. Thank you for your arguments. Like I said, we'd love to come down and shake your hand in our normal tradition of the Fourth Circuit, but under circumstance we cannot. But know that we appreciate your arguments and your help on these cases, and we appreciate it. And I wish that you'll be safe and stay well. Take care. All right, bye-bye. Come up. Atkinson, when you're ready.
Thank you. May it please the court, I'm John Mark Atkinson. I represent James Randy Schoonover and have reserved 7 minutes of rebuttal. The right of a non-threatening, non-flight risk, non-resisting elderly amputee charged or detained for minor nonviolent offenses to be free from the excessive force of being handcuffed from his wrist directly to his ankle is clearly established under federal law. And that right is clearly established under federal law because police officers are required and must take known injuries or objectively obvious injuries into consideration when handcuffing cooperative individuals who meet that same criteria. Not violent, not fighting back, not threatening. Therefore, the defendant officers in this case are not entitled to qualified immunity, and I'm asking this court to reverse the lower court's order dismissing the plaintiff's excessive force claim against those individuals and remand the case to district court.
Let me ask you something. It's a question of whether we're arguing in the right ballpark. The complaint, as I understand it, does not indicate that your client resisted, fought back. The implication is that basically when he said he was under arrest, he submitted and they handcuffed him. And because his lower left arm was amputated, they used his leg instead of the left arm to maintain him in security. In Graham versus Connor, there's a footnote that describes the whole doctrine of the excessive force. And it limits that doctrine to bringing that person into custody. When a person resists or runs or flees, Garner was a person shot in the back. These are all excessive force in bringing somebody into custody. And they limit it exclusively, and they have said that when you get them into custody, you're actually under the Due Process Clause, not the Fourth Amendment. And the excessive force standard is not the Graham versus Connor. I think the question might appropriately be raised is, since the district court analyzed the whole thing under Graham versus Connor, maybe we should send it back and have it be analyzed under the Due Process Clause, which I think may have a different approach to whether this was appropriate or not. Because we have the question of, well, there was some argument about how do you handcuff somebody who has only one hand? The question is whether you needed to handcuff him, but that's a totally different question. Police, presumably, when they take somebody to the station, usually cuff them they don't want them running, opening the door. They don't want them hurting the police officers or whatever. And that whole analysis we don't have before us. And wouldn't it be better for the district court to look at this under the Due Process Clause? That's my fundamental question. It may not get there the way you want it to, but you're asking for a remand, and maybe that's the right approach.
Yeah, we certainly would be open to exploring that and evaluating this case under that standard, under the Due Process Clause. But I think in addition to that, based on our brief and what we'll argue today, that this case should be remanded on a Fourth Amendment analysis as well.
That's my point. Is there any Fourth Amendment problem? In other words, the Fourth Amendment is the seizure and resistance to seizure and the police conduct in bringing somebody into custody. They billy club them, they kick them, they hold them back with their foot in the middle of the back trying to get them cuffed, and they stun gun him or they shoot him. These cases are all over, but they're all the Graham Connor kind of cases. And the Supreme Court expressly said we do not address the portion after he's in custody, and we do not apply this. They say we leave that for another day as to how you apply it. And since then, of course, everybody knows it's a Due Process Clause is the appropriate after he's in. And here he apparently submitted without resistance. At least that's what appears on the complaint. There's no evidence that he fled or is running or they beat him or tackled him or whatever. In view of that, it seems to me we would be helped much better, wouldn't we, to have the analysis not conducted under Graham, but have it conducted under, for instance, we have the Robles case. That's the closest I could come to. And in the Robles case, police officers handcuffed somebody to a pole, a light pole. They were transferring him from one county to another. They attached him to a light pole. He was there for about 10 minutes till the other county picked him up. And that was analyzed under the Due Process Clause as an inappropriate use of cuffing. And I think that's your argument. This was an inappropriate method of cuffing him.
And the one question, Your Honor, I admit I'm unsure of what the answer would be, is at what point does the taking him into custody begin and end?
Well, that's a good question. It's absolutely a good question because it's blurred, and the conduct during cuffing, I would think, can violate the Fourth Amendment. In other words, they can break somebody's wrists or they can bend his arms back when they're cuffing him. But in this case, there's no evidence of that. This case is basically how do they maintain the security over him was the cuffing method an appropriate method? And it was, you make a good argument that it was demeaning, but I think there were two questions that we would need to ask. Number one is analyze it under the Due Process Clause, and two, whether an officer should have known about that analysis. But we don't have all that case law here. We did a little bit of our own research, and the only case we could find was the Robles case, where we did address the cuffing method, and that might be some guidance for you.
Yes.
Robles.
Thank you. And our view may be that they should be evaluated under both, at least initially when he's first cuffed. I mean, at what point does that end and it becomes a due process question? And as you,
I couldn't understand your argument, I mean, in terms of what your position is, because your complaint seemed to me, you're saying that he shouldn't have been arrested at all, because you said that they came on private property and said, give me ask questions and those things like that, and never said anything at all. He went into the house and said he called the magistrate, and they said, okay, you're under arrest because you called a magistrate. That's what you said. So the district court judge focused on, well, I think it was kind of excessive under the circumstances, because the normal way to take anyone in transport is to cuff them, as Judge Niemeyer said. That's great. But you don't have a question about that he shouldn't have been cuffed at all by any means? Or is that your complaint, or am I wrong?
no, we agree that, and have pled and have argued that under these circumstances, he could have just been, if they insisted on taking him into custody, which they could have just written him
I think you missed my question. My question is, do you have an argument that he should not have been placed in cuffs at all, period? You just, for example, the way your complaint reads is like a police officer sees me on the street and say, hey, how you doing? What's your name? I said, well, my name is Roger. Well, you know, I'm going to arrest you because, I don't know, I saw you walking out of the magistrate's office, and I'm going to arrest you. I wouldn't be concerned so much that how he cuffed me. I'd be concerned that the fact that he cuffed me as gently as he possibly could have. I mean, maybe, I'm just saying, did your complaint read like that?
Right, we didn't file a specific false arrest cause of action. We did plead and pointed out the fact that he was told.
Are you okay with being cuffed? Your only argument is that he cuffed him the wrong way?
Well, I don't think he should have necessarily been cuffed at all, given his situation, his age, and the...
Now that's a whole different proposition, it seems to me. If you say, let's assume he had two good hands. He was missing his left hand, but let's assume he had two good hands. It would seem to me that the normal police procedure that's followed in probably 95% of the time, you never take somebody in a car uncuffed. He could get out the door, he could choke the officer, he could hit somebody. It's just a normal procedure. You're taking him to the police station if you have a proper arrest. Now, the Judge Gregory you alleged something suggesting there was an improper arrest, but that's not alleged. And I thought the complaint was alleging that the cuffing was an inappropriate method of cuffing. That's what I thought your point was, and you were trying to address it under the Fourth Amendment, and I'm suggesting that would be probably a due process clause. There was no resistance in bringing him into custody. You're under arrest, and I'm going to cuff you. And the officer just picked the wrong way to cuff. That would be your argument, I gather.
Yes, and there's 2 points to that, and then I'll...
But I guess we need to know you're not raising false arrest, even though you suggested it. Now, I think the record shows he did have a warrant out or something else, didn't he? He was subject to arrest.
Yeah, he was told, I'm arresting you because you called the magistrate, but he was later charged with not having proper registration and license, and that's undisputed that he didn't have that information. That's why a false arrest charge wasn't brought in, or cause of action wasn't pled in the complaint.
You said that police officers had that information before they took him away?
Well, there was also the receiving of stolen property based on the tags, correct? On the
Yes, ma'am.
car?
Yeah, so what the officers, what turned out in this case from his testimony, that's not in front of the court on the response, is that he,
This is a motion to dismiss?
yes, sir.
So why do we have all this record and this evidence?
Well, because the court received all the briefs and didn't file an order or issue an order or memorandum of opinion for 10 months, so we continue to discover the case.
Oh, I see.
And there were certain aspects of
But
the
it still
criminal...
the court didn't turn it into a Rule 56 motion, did it?
That's correct. The defendants did,
On a motion to dismiss.
right. But the defendants did attach exhibits to their
Did you
response.
object to those attachments?
We did not.
Why not?
Well, because all they show is what we actually think that
They
isn't,
showed a whole lot. I read them. They got in a lot of evidence.
well, and the other thing is their court records. So the courts have taken judicial notice of what that is to
Oh, you
argue
said
that.
motion to dismiss can be augmented by just judicial notice about facts normally?
No.
No, it can't. I mean,
Right.
are
I
you,
think we felt it can.
well,
On a 12b6, you can incorporate documents that are referred to in the complaint and documents that are, of which we can take judicial notice. I think we've held that.
yeah, but
Right.
you didn't refer to those in your complaint.
I did not. They were
Notice matters.
exhibits to the defendant's answer. And exhibits to the defendant's response to the motion, or to their motion to dismiss in
What
the
is it
first place.
before us now? It's just immunity?
Yes, qualified immunity only whether it was
That's the
clearly
only issue
established.
before us?
Yes, sir.
Well,
The issue is, was there qualified immunity for these officers' actions based on, was there clear notice of that? And we've cited to countless, well, not countless, but a number of cases and other cases referred to where officers were aware of someone's physical limitations, failed to accommodate those, and the courts have held that was a clear notice that they committed excessive force against that individual, and the case should have gone
Not
forward.
excessive force, it's just improper cuffing.
Well,
According to your allegation, I'm not sure it is because we don't have much evidence on it, but there was no resistance, there was no pushing back, basically they were taking him into custody.
yes, but by placing him like this, given his
Yeah,
condition, and
one-
putting him in a car
one
like
arm
that
to
the
the
whole
one
time.
leg.
Right. And transporting him to a vehicle like that, and there's cases that have held that that can by itself
Well,
be
they cuffed him to
excessive
get into
force.
the vehicle, and apparently they didn't know how to cuff him any other way. That's the way they came up with. The judge talked about the possibility of cuffing him to a belt hook or something like this. But it seems to me the argument here is how's the proper way to maintain somebody in custody? How to cuff him? It's not that there was force used. He wasn't kicked. He wasn't beaten. He was cuffed in a strange way. And that's because, of course, he didn't have his left hand.
But district court found it was excessive.
That's correct.
Absolutely. So you won the battle, but you lost the war of clearly established.
That's correct.
But on this record, the district court said it was excessive.
Did any reasonable officer know that was excessive force? And we're arguing today that it is clearly established and that qualified
They
immunity does not
analyzed it
apply.
under Graham versus Connor, and the Supreme Court has twice, I think, said that that is not the right analysis.
Well, there are lots of cases that have held that cuffing alone can be excessive force that we've referred to.
Okay.
That's past my time.
Okay. Thank you. Thank you, Ms. Atkinson. Mr. Adkins?
Thank you, Your Honor. May it please the court. I'm Dranon Adkins. I represent Jonathan Holcomb and Michael Morris, both of whom were the deputy sheriffs involved in this case. As the court was asking, the only issue that's truly before the court is whether it was clearly established as of September 27, 2019, that this particular method of handcuffing violated the Fourth Amendment, because that is how the case was pled. Down below, the district court held that the right at issue in this case has not been clearly established, at least in this circuit, and that therefore the deputies were entitled to qualified immunity. Judge Gregory, to your point, plaintiff did win the war. The court found that, as alleged in the complaint, it was excessive. It was unreasonable. But that's not the end of the qualified immunity analysis, and that's where we won. We ended up winning the war. He won the battle. And qualified immunity is designed to ensure that government officials are only held responsible when their conduct violates clearly established laws. And those laws must be established prior to the time of the challenge conduct. And here, there's nothing, unfortunately, in the Supreme Court jurisdiction or jurisprudence or this court's jurisprudence that frames this issue of improper method of handcuffing such that these officers knew that this would violate Mr. Schoonover's rights. So excuse me. The framing on the qualified immunity issue is really important. And we think that the district court properly framed and properly rejected plaintiff's framing of this as just the general right to be free from excessive force. And the court said the district court said that was way too general, that, under Fourth Amendment jurisdiction, especially in qualified immunity context, you have to define it at an appropriate level of particularity. And that's what the district court did. It held that when defined at the appropriate level, that the law is not clearly established.
You also have a pretty uphill battle to show that every reasonable officer would have known. Every reasonable officer would have known.
That's correct. That's correct. So, based on the way that this case was pled and the way that it was framed in the district court, and the framing by being what is the right at issue, that's really what we're here on, is did the district court properly apply the qualified immunity analysis in this case? And we submit that it did, in finding that there is no clearly established law. There is nothing in this court's jurisprudence concerning handcuffing except for Brown and Dolgus. The Brown case was from 2002, in which this court held that handcuffing would rarely constitute excessive force when an arrest is justified. Here we have a justified arrest.
That's why I question you. We have a sort of justified arrest, the way it was framed, and counsel has conceded that he's not objecting to the fact that he was arrested at all. All that's across the board. So if you could be arrested, you have to be transported. You have to be transported, you have to be cuffed. All right, that's established. Tell me this, then, how is it that the district court found that as pleaded, and you qualified, that it was excessive? What part as pleaded made it excessive?
I think the part
the finding of the court. Go ahead.
I think that, so when the court ultimately reached the conclusion on the reasonableness of the application of handcuffs, that was directly after it looked at the alternatives that plaintiff had suggested that could have been used in handcuffing. Belt loop, daisy chaining multiple cuffs together, and the court considered those to be reasonable alternatives, and that as compared to what is alleged in the complaint, because there are no allegations of any of these reasonable alternatives or whether the officers considered them or anything.
But would they know that in the complaint? Would plaintiff know that?
We take the complaint as we get it. So plaintiff's argument is based upon something that they think could have happened, and it did happen, and quite frankly, it's based on something that evidence that's not before the court would show that was impossible to happen. For instance, the argument that belt loops could have been used. Well, this wasn't before the district court, but there's a subsequent video of Mr. Schoonover where he's wearing sweatpants or cut-off shorts or something. There's nothing like that that can happen.
But the complaint alleges some animals, doesn't it?
Well, under the Fourth Amendment, their motivation.
Right, I know the subjective intent doesn't matter.
Correct.
So you'll concede all the animals.
For purposes of this argument, yes. We would concede that that is alleged. And for purposes of a motion to dismiss, we have to take facts as pled. and accept facts as pled. We don't have to accept legal conclusions. But for purposes of our motion to dismiss, I think we even put that in our introductory motion, is we accept the facts as pled, although we dispute what they are.
So how do you ever get to any metric of any finding? Because you said they did it this way, but there are two other ways that would have been better, maybe by the belt or by the daisy chain and all those things. What would require at all, from a standpoint of precedent, him to or them to pick one over the other?
Well, that was the purpose of our argument on qualified immunity. What are they to do?
Right.
We're supposed to have guidance from courts, and especially for law enforcement officers. They're supposed to have guidance as to what conduct is or is not permissible. And when you have novel situations, which I think everyone would agree that this is a very novel situation, what are they to do? And if they make a mistake in what they do, and a court later says, well, you shouldn't have done that, that's the purpose of qualified immunity.
In a case like this, once you get past that, you can see, as the plaintiff has, that the arrest was appropriate and authorized, and transporting him, it's almost like you have to have some standard of compassionate arrest, sort of, because of his circumstances physically and his age. There was a need to compassionately say, well, we're not going to treat you like we normally treat other people because of your age and the circumstances, and transport you in a different manner. I mean, I don't know how else you would deal with it other than a compassion, because I don't know if there's anything that compels an alternative form of transportation.
And Your Honor, I don't know how to answer that. I think in practice, that's probably what should happen. I know it's alleged that there was no compassion shown to Mr. Schoonover. However, again, stuff that's not before this court, because it wasn't before the district court, there was compassion shown to him. Of course, if this is remanded for summary judgment or additional briefing, I believe that all would probably come in at that point.
You mean to us about the aspirin and let him take the aspirin and that kind of thing?
No, it's about the.
Well, don't go into it, but if you, like you said.
I don't want to.
No, keep your powder dry. We don't have to do that. All right, go ahead.
So going back to Brown and Dolgus, so Brown's a 2002 case. If they're arrested, they're allowed to be placed in cuffs. Dolgus is, of course, this court's case on handcuffing a elementary school student. And
10-year-old girl.
A 10-year-old girl.
You know the case well.
I'm sure the court does. And Dolgus is kind of enlightening to me, because what this court did in Dolgus is exactly what Judge Copenhaver did below. It was look at what was alleged, look at what happened, determine that the officer's conduct was unreasonable, and still grant qualified immunity because the law wasn't clearly established. And we submit that this is the same thing that should happen in this case. And again, I'll just harp or touch on a point that my friend has made about what right is an issue. Again, the Fourth Circuit has never recognized this right that Mr. Schoonover wishes the court to adopt. That has been basically adopted in the Sixth Circuit, kind of in the Eighth Circuit and 10th Circuit, although each of those circuits have subsequently modified their holdings. The Sixth Circuit started off as the right to be free from excessive force in handcuffing cases, and now they've got what's essentially a three-part test of you have to complain about the handcuffing, the officers have to ignore your complaints, and you have to have some subjective manifestation of injury regarding those complaints. And what I've gathered from these cases is that essentially what happens in those cases is that the complaint of a prior condition or injury is what is injured during the handcuffing. So in those cases, for instance, someone has a torn rotator cuff, I can't put my arms behind my back. You put my arms behind my back, it re-tears my rotator cuff. Here, there is no such allegations that his condition, which is the not having his left hand, was exacerbated or aggravated by the method of handcuffing. All the complaint says is that he was injured physically and mentally. So we don't think even under their standard that they're meeting what the 6th, 8th, and 10th circuits would say. But even then, I don't think that 3 circuits that have kind of been wishy-washy on what their case law is a consensus that the court can look to. We point to a number of other cases from other circuits that dispute that. We've got the 11th Circuit, the 7th Circuit, and the 5th Circuit that all have differing standards with respect to handcuffing cases. So we don't believe that 3 circuits can establish a consensus, and I think that the case from 2 years ago, I'm going to butcher this name, the Fidzikowski v. Wheeler, the court looked at this issue on the robust consensus issue and held that case law from 3 sister circuits is not a robust consensus. And that's kind of been repeated. Now, contrast that to Booker. The Booker case, 855 F. 3rd 533, the court did find a robust consensus when 10 of 13 circuits had agreed on certain rights. But here we have 3. We have 3 others that kind of dispute what the 6th Circuit has done. I know the 1st Circuit has also done, not held in line with the 6th, and that was the Hunt v. Massey case that we cited in our brief. So we think under any analysis on the clearly established that it's not there, and that's why we filed our motion, and we believe that's why the district court granted our motion. So we would ask this court to affirm, because this is precisely the situation that qualified immunity should apply.
All right.
Unless the court has any questions for me.
Thank you, Mr. Atkins. Mr. Atkinson.
Thank you. The issue I want to address most clearly is this one of a consensus of persuasive authority. We haven't found any cases in the 4th Circuit of the United States Supreme Court where an amputee was cuffed from wrist to ankle. Suggests the reason is because it's pretty outlandish behavior in the first place. However, the question of whether there is a split in the circuits over this issue is an overgeneralization. What we would argue is the 6th, 8th, and 10th Circuit cite cases that argue that if an officer is told about an injury and he can handcuff someone in front of them instead of behind their back and chooses not to do so, that can be an excessive force claim, that a clearly established right of excessive force.
What's the option in your case, in this case?
What they could have done for him?
Yeah.
They could have put a belt on him and attached a cuff to that. They could have hooked it to his pants. They could have, it was a nonviolent traffic offense. They could have put him in the back of the car without cuffing at all in a cage.
In what case, you cited one where someone suggested, I need you to do it from the front because in the back I have a problem. But there's no evidence here that there was a suggestion that physically it would have been better. Is there evidence that he said, listen, you can't do that. My back would be strained in a transport if because that is awkward. You bend down, you have to stay bent down for a period of time. Is anything you have, did you plead that he was injured or all?
We did plead that he suffered injuries as a result of the excessive force.
Oh, no, I mean in the sense of that he objected to it and said, don't do it this way and do it this way.
We didn't plead specific facts in the complaint that he told the officer, please don't do this because it would hurt my back or hurt my
Or no
body.
suggesting any alternatives. Right.
He didn't
suggest
volunteer them to the officer, no.
And you have any evidence that they've ever used those alternative methods before?
Well, when we discovered the case, we learned that they were trained, and in their policy, it talks about if you're transporting a disabled person, you need to use your common sense, and it offers those options that we've discussed as available to those specific officers in their own policy, which is part of the reason we argued this case was prematurely ruled on as a motion to dismiss.
One of the problems that policies don't equate to clearly established law.
Correct, not on their own. However, they can be evidence of fair notice to the officers of what's available to them and what's reasonable under the circumstances. What I would point out as a distinction between the 6th, 8th, and 10th Circuit cases, those were cases where people didn't have outwardly obvious injuries, and they told the officers, hey, my shoulders is hurt, I had surgery, and the officers, if they didn't take that into account, would have been able to be held for excessive force. The other circuits have gone the other way on that specific issue that, well, if I didn't see obvious evidence of an injury, how am I supposed to know that that actually would cause some harm to the person? Maybe they're just saying that because they don't want to be handcuffed.
Well, qualified immunity is about notice to the officers. And so if there's no common standard used by the circuits, or all of the circuits are consistent about, or at least a majority, how can we say that these officers would have had notice in this situation?
The way I think it's clear and there is a consensus, there are no cases that I found where a person being detained who had an obvious injury, a sling on their arm or missing an arm like my client, where any officers refused to accommodate them and the court upheld that, saying that's not excessive force. So these other circuits, the 1st, 5th, 7th, and 11th, cited by the defendants in their brief, argue, well, we didn't have obvious evidence of that. We were just told by these suspects that they had this injury.
They didn't damage or injure his bad arm. What they did is they took his good arm and they needed to cuff it somewhere. And they made a decision, I guess, common sense, which was good or bad. And you said, of course, it's bad. You get the benefit of that. But it was not a situation where they were hurting his bad arm and not accommodating him. What they were trying to do is to figure out how to cuff him with one good arm, and which is a little different.
Yeah, but by doing so, hurt that arm and that back and that part of his body. But as was clearly pointed out, the district court ruled it said the conduct was so extreme that any reasonable officer would know that was inappropriate and excessive force. And
Don't you have to have a case?
What's that?
Don't you have to have a case where every officer, every single reasonable officer would know that that violated constitutional rights?
Well, in the two-step process for a qualified immunity, the court ruled that it was unreasonable that no officer would think that was appropriate.
We're here on review of the court.
Right. On that part, but on the second part, the court ruled that there wasn't a clear standard or a clearly established right. And to your point, Judge, we think if there's ever a situation where someone has an obvious injury and the officers, there's no case that says if you have an obvious injury and they fail to accommodate that cannot stand as an excessive force claim. We would argue that should be the standard that should be applied. That falls in each of these cases, and my client's case can be distinguished from the ones in the First Circuit, 5th, 7th. For that reason, he had an obvious injury. There's no dispute. He's wearing a T-shirt.
They actually accommodated that. They tried to cuff him in a way that wouldn't use that arm.
Well, they couldn't put a handcuff on his stub of his arm because it wouldn't stay.
If they were designing something, we're speculating now, you could tie that arm around the back with a flex to the other arm, but they left that arm alone. That was the injured arm, but it was not a need to accommodate that. It was a need to figure out how to cuff him.
Well, and we would dispute that they were accommodating him by doing that. I mean, there's evidence in the complaint that they mocked him for the way he was walking as well.
They didn't increase the injury or damage the injury or not accommodate it. They were confronted with a circumstance that they were trying to solve.
Right. And our argument is...
Yeah, I understand.
Do you have a more favorable impression or response to Judge Nehemiah's first suggestion about a remand for standard?
Yeah, I think it's an excellent point that there's a point once the handcuffs... We do not oppose that. Once you're cuffed, at what point does that become a due process argument? And we should be evaluating that under that. We'd be happy to do so.
No, the only thing I pointed out to you is this Robles case that we decided, and that was a cuffing issue, and whether it's appropriate cuffing, and we analyzed that under the due process clause.
Thank you. And the only thing I'd add is the only other distinction with our case is that all of these cases where the court felt there was a clearly established right of excessive force dealt with situations like ours where the client was not combative, was not fighting back, was not at risk of flight. And due to that and his obvious injury, we think there was a clearly established right. And we ask the court to reverse and remand. Thank you.
Thank you so much, Mr. Atkinson and Mr. Atkins for your arguments. We'd love to come down and greet you, but we cannot. But know very much that we appreciate your being here and your arguments to help us on this case. Thank you so much. And with that, I'll ask the clerk to adjourn us for the day.
This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.